Okay, thank you. Good evening, everyone. It's 7:30 and I'd now like to start the meeting. Welcome to this special meeting of the Standards Committee, which is a remote meeting, and please do note it's being live streamed and recorded. I'm Richard Stowe, independent member and chair of the committee. Our special meeting has a single business item, which is a joint dispensation request from County Councillor Tudor Thomas and from Maggie Harris, who is a co-opted member of the Children and Young Persons Select Committee. This item is urgent as it needs to be resolved prior to full council on Thursday, 22nd of July. The dispensation form, the application form, which is part of your papers, which has been produced, is detailed and clear, and I'm grateful that Councillor Thomas is attending the meeting tonight to support the application and will have the opportunity both to speak and to answer any questions from members. Before we start on the agenda, could members please mute your microphones when not speaking? It's up to you whether you switch off video. And also, point 2, could you identify yourself when you first speak? Because there's no automatic name display on the video coverage. So the first item is item 1, apologies for absence. Do we have any apologies other than Richard McGonigal? I don't think so. I think although Peter Easy is not present.
Sorry, Chair. Yeah, no, I haven't received any other apologies.
Okay. Declarations of interest. Any declarations of interest, or shall we do the usual as and when? No declarations? It's fine. Item 3, which is the business item, is the dispensation request. And what I propose is that we handle this as follows. First, I'll ask Matt Phillips as monitoring officer to present his report, the officer report, and also talk about Appendix 1. I'll then ask Councillor Thomas if he would like to make any introductory comments, particularly anything not covered in the written application or anything he would like to emphasise. And after that, I'll take the members through each of the 5 grounds for dispensation which are included in the application and do those in turn, and we'll determine whether we as a committee, whether we support them and whether we consider them to be valid. And at that point, if necessary, members will have the chance to ask questions of Councillor Thomas. So does anyone have any questions on the process? Thank you. Well, in that case, I'd like to start by asking Matt to present his officer report. Over to you, Matt.
Chair, thank you very much. Good evening, everyone. So I'm Matt Phillips, Chief Officer, People and Governance for Monmouthshire County Council, and I'm also the monitoring officer. Thank you, first of all, Chair and everyone else for coming together at such short notice. I appreciate the nature of dispensation requests is that they can come in at relatively short notice, and then there's quite a lot of upheaval. So I'm very grateful for everyone who's been able to attend this evening, and similarly to Councillor Thomas, who's been able to join as well. The urgency that you referred to, Chair, as well is because while the original question arose with regard to a Children and Young People's Select Committee, actually there'll be a full meeting of council next week, which this will have an impact on in terms of Councillor Thomas's ability to contribute. So once again, yeah, thank you very much. So this is this relates to I mean the report sets it out, and it's available to all members of the public who wish to access it. It's on the website, and it relates to the ongoing work and discussions and consultation that with regard to education provision within Abergavenny town. Specifically, there are 3 schools that this is of particular relevance to: the King Henry VIII Secondary School, Derryview Primary School, and Ysgolfenni, the Welsh school, primary school. The reason it affects those 3 schools particularly is because any decision relating to the all-age provision within the town will take effect on the site of what is currently King Henry II Secondary School. It would amalgamate both that school and Derryview Primary School, and it would result in Ysgolfenni potentially moving then onto one of the other sites. So that's why those 3 schools are of relevance here. So the question arose in preparing for the CYP Select Committee as to what the status of either personal or prejudicial interests of the committee members were, partly because there are co-opted members, which is a slightly different regime to elected members, and partly because unusually there's actually quite a large number of elected members who sit on the committee who are governors of schools in Abergavenny and even a bit further afield who are affected by the catchment area. So I had to, as is my duty, I had to look into the matter. I consulted with the Code of Conduct, which is set out in the 5th part of our Constitution. It's the model Code of Conduct that the majority of both local authorities and community councils use across Wales. There's been no specific amendments made in relation to Monmouthshire, and just in examining the relevant parts of it, which are set out in the report, which are predominantly paras 10, which covers personal interests, and 12, which covers prejudicial interests. It was my view initially that there was the potential for there to be a prejudicial interest sat with any of the members of CYP Select who also were governors of those 3 schools, and that's because of, if you see at 3.6 in the report, and the normal caveat when it comes to governors is set out in as much as that you will not be regarded as having prejudicial interest where that business relates to your role as a school governor, but it's then qualified later on unless it relates particularly to the school. So we had this quite unusual situation where there's 3 schools that are particularly affected. Then I needed to do some, so the original advice that I set out is the one that's referenced at Appendix 1, and that's a document that's copied from an email that was sent to the members of the Select Committee. I then, on examining further actually how individuals were appointed to the different boards of governors, managed to establish that actually the majority of members who were sitting on the governors were appointed there by Monmouthshire County Council. So you can see again in that 3.6 under subsection 3 that you're not regarded as having prejudicial interest. So there's an exemption here if it's a body to which you've been appointed by your authority. And then, of course, under 4, that's captured within the brackets where not appointed or nominated by your authority. So that reduced, because of anyone who was appointed by MCC as your authority to the governors, it meant that the exemption applied to them, but it left Councillor Thomas and Maggie Harris, who was a co-opted member, who were both appointed to their boards of governors by their community councils. And so you can see thereafter within within the context of the report, actually, you can see that I've updated and amended my original advice, by which I thought that all governors were going to be affected, to the fact that actually no, the exemption applied with the exception of these 2, Councillor Thomas and Maggie Harris. I think in terms of my experience of dealing with the Code of Conduct and how we usually deal with matters that arise in relation to discussions around education and governors, it is usually a fairly standard process whereby we would deem it at most a personal interest, but a conversation and discussion and vote would continue. It was the unusual specificity of the 3 schools that were affected here, which resulted in my advice. I think, to offer an opinion in terms of the wider experience I had of the code and conversations with other monitoring officers, I think this is probably an aberration, and it's an unintended consequence of the way that the code is written, that we've ended up with 2 named individuals who've been affected in this way and require dispensation. Chair, I think that sets out the background and my advice, and then my conclusions within the report. I don't intend on going into the dispensation application itself, because of course that's a matter for you and the committee, but I'm happy to take any questions at this point.
Are there any questions for Matt before we move on? Matt, I notice that Peter Easy has joined you. Yes, good evening. Okay, I'll now ask Councillor Thomas if he would like to make any introductory comments about the dispensation application, particularly anything not covered in the written application or anything that he would like to emphasise, and then you members will have the opportunity to ask questions of Councillor Thomas as we move through the grounds for dispensation in the application form.
Okay, excuse me. Thank you, Chair, and thanks members for obviously allowing me to come tonight to actually put my point of view for myself and as Chair of Children and Young People, but also on behalf of Councillor Maggie Harris. And I certainly appreciate that. One thing, I don't want to go through the whole application, but one thing I would say, I've lived in Abergavenny for 38 years. As my accent belies, I'm not from this area originally, but I've lived here. I taught in King Henry for 12 years, brought 3 children up here, one who went into English medium and went to King Henry, and 2 others who went into Welsh medium. I'm mayor, I'm obviously town and county councillor for Priory in Abergavenny. And I'd like to think I know the scene in education. Obviously taught, then I went to work for the exam board, and I worked across Wales in both languages and in fact in a large number of schools in England. So I think I've got a reasonable breadth of experience. And I have no personal interest in the development of the brand new school in Abergavenny, other than representing people in my ward. But I think more importantly, now that I hold the position of mayor, I am representing the whole of Abergavenny, and people with children going to that school, or people with grandchildren and so on. So I think it's important that I am allowed to speak, and that I in CYP and in full council, and that I represent the interests of those people. And the same applies, Maggie Harris, I'm on the governing body of Ysgol Gymraeg Efenni, and that's where the difficulty comes. Maggie is there for the Monmouthshire Association of School Governors. She's vice chair of Derry View governing body, and again she's got a broad depth of knowledge about that school and about the area. So I think it's important that we both have the opportunity to take part. This is a monumental development, millions of pounds, affecting hundreds of children. So it's not a minor development, and I think it needs to be very carefully scrutinised. And if I am not there, and if Maggie Harris is not there, then the scrutiny process will, I think, be much poorer in a sense. It will not have that breadth. And I can honestly say that I have no interest. I can see to a certain extent, obviously I'm on the governing body of Ysgol Gymraeg Efenni, and that if this development goes through, it will move into the Derry View site, and I can understand that. What I find difficult to understand, and perhaps I'm being a little bit unintelligent here, is the fact that other colleagues who are county councillors and are on governing bodies from the major authority will be allowed to speak, but because I am there from the town council, a minor authority, and Maggie is from Mask, then we will not be allowed to speak. And it's not a criticism in any way of this committee. It is just stating the facts as the rules and regulations stand, and I find that quite difficult to understand, and I do think people in Abergavenny will find that quite difficult to understand. I don't think I want to say much more than that. Obviously happy to answer questions, but one thing I would say, I've obviously taken advice from the party that I belong to, the group, and obviously if I'm not given dispensation, then obviously I will not speak. I will not take part in the process. I will follow whatever is decided here tonight, even though perhaps I disagree with that. If I carried on and spoke or took part, then if somebody brought a complaint, then obviously I could be personally liable. But I am a person who does like to follow the rules. I come from a sort of regulatory sort of background with the exam board, but I will obviously observe that. I will not then take part. I will withdraw as chair, and I will not obviously speak and take part in the process. So I think that's where I'm at the moment. Thanks.
Okay, thank you very much for that introduction. And I do understand your frustration with this situation, which actually comes from the paragraphs in the code 12.2.A3 and 12.2.A4, and it's the subclause 3, which means that your colleagues who are governors but are nominated by Monmouthshire County Council get this exemption. This is in the code. However, the situation for you and Maggie Harris is because you're not governors through being nominated by Monmouthshire County Council. Peculiarly, perhaps, or absurdly, depending on your viewpoint, you don't get an exemption, and that's in the code. However, it's within our power as the Standards Committee to consider your reasons and the grounds and to grant a dispensation, irrespective of that anomaly or curious provision inside the code. And so what we'll now do is we'll go through the 5 grounds for dispensation in your application form, and we'll get comments and feedback from the members. If necessary, they may want to ask you questions about the points you've made. And in turn, on each of them, we'll say, as a committee, do we support that? Do we think that's valid grounds? Positively for you, you only need to succeed on 1 ground, and we can grant a dispensation. However, I would like to go through all 5 because of the effort and the detail you put into the form. So that's the process from now.
Thanks.
Okay. So, members, if we're now looking at the dispensation application form on section 8, which is on page 3, and this goes through in detail the 5 grounds for dispensation. These are 5 grounds selected from the 10 which are available to us as a Standards Committee in the 2001 regulations as amended in 2016. The 2016 amendment, you may remember, gave us ground J, which is what I call the catch-all ground. It appears to the committee to be otherwise appropriate to grant a dispensation. So taking these in turn, if we start with ground D, the nature of the member's interest is such that the member's participation in the business to which the interest relates would not damage public confidence in the conduct of the relevant authority's business. And I would summarise the argument there by actually in this situation is that the opposite would be true, to exclude governors, voluntary unpaid governors with considerable expertise in this situation where a proposal will have major effects on 3 schools would actually, the exclusion or the gagging of certain governors for these reasons would have the opposite effect on public confidence. Do members have any views or comments on that or questions? Irene, I can see your hand up.
Irene Cameron, can I ask Councillor Thomas, has the public approached him on this subject?
I mean, purely not officially, but in passing, and obviously, having lived here for so long, I know so many people. But I think some people, in passing, have expressed surprise. If I were not allowed to represent interest, but I've had no formal letter or telephone calls. But as I say, holding the position, county councillor, but also mayor and town and county council, and being on the governing body. The Welsh School obviously covers the whole of the town. Its catchment is very broad, as is obviously King Henry. So I think there is a strong expectation there that I would be allowed to represent their interests, and and that's a gut feeling as well.
Thank you.
Yes, thank you. Can I just ask Matt just to confirm, now that we have Peter Easy present as a member, that we could reinstate Irene as a voting member?
Thanks, Chair. So just to explain, the way a Standards Committee works for anyone watching at home or on the recording is that you always have to have at least 50% of the voting members are independent members. So we have three, with Peter Easy having just joined us, we have three independent members today. So Richard as chair, Peter, and then Rian as well. And so that allows us three elected members to join. And we'd worked out previously that we would have councillors Peter Clark and David Evans as the voting elected members. Now that Peter has bumped the numbers up one more, I think the proposal that Irene joins as a voter as well as a contributor is probably entirely appropriate. So if the rest of the committee are happy with that, I think that makes a lot of sense.
Yeah. Yes, thank you. So members, back to Ground D. You members generally, are you in support of that in general? Do you have any questions about it? Do you think it's a strong argument?
I have put my hand up, but I'm not sure anyone's noticed.
Oh, sorry, I'm not even looking at the chat thing. Thank you, Rian. Please go ahead.
I'd like to address the question to Councillor Thomas, if I may. You've just told us that you represent the whole of Abergavenny because the catchment of Ysgolefenny and King Henry represents the whole of Abergavenny. What about Derry View? I'm not familiar with the catchments of Abergavenny. So is there anyone else who could represent Ms Harris's position, or is it only Ms Harris that could represent Derry View's position on the decision committee?
Yeah, in terms of that, County Councillor Martin Grocott is the member for Lansdowne Ward, and both King Henry and Derry View sit within his ward, and obviously he knows that ward quite well, obviously very well. And again, he comes from a teaching background and is deputy director for a big English authority in England. So, you know, he possibly could, but I know for a fact that he's away in September, so, you know, he's not going to be probably at CYP. And I do think Derry View sits just above King Henry and has quite a challenging catchment, and parents who probably don't feel terribly confident to put forward their views. And somebody like Maggie Harris, who is has been chair, now is vice chair, obviously is confident, knows the area, knows the families, knows the patch, and I think she would stand up in that sense and represent the views of Derry View. And some of those parents would not have that sort of aptitude or confidence to do that. So I feel strongly, that she should be there as well as myself. You know, it's not purely from, I happen to be here tonight because I'm chair, but I represent both her interests. I think it's very important that she is there, and she's somebody who's been involved for many years, so is close to it. Thanks.
Okay, so she would be there advocating very strongly for the parents and children of Derry View on the basis of her personal knowledge and her connections to the school of long standing as a vice chair and as a governor. Yes,
and she's somebody who's been who's highly respected. She's been a town councillor for many years, and her children went through King Henry. In fact, I taught them. Husband's a county councillor, Roger Harris, but she is somebody who is seen as somebody who is a fair and an honourable person and representative of people's interest in that area. And I think that is significant in a catchment like Derry View, which really is more challenging than perhaps the catchment of other schools in the authority.
Okay, that's very clear. So Councillor Grocott can represent as well. He will be absent, but Ms Harris has a particular position on this and can be present in September and can also present as a strong advocate for parents and children of that school.
Yes.
Thank you very much. Thank you, Chair.
Thank you. Matt, I've got a question here. I was thinking of an alternative way to proceed here is we could go through all the 5 grounds and simply at the end then ask members in a simple vote whether they approve of a dispensation or not. Is that a better way of doing things?
It's entirely up to you, Chair, but that makes a lot of sense to me.
Okay, well, that's what we'll do then, members. We'll work through the grounds. We'll move on then to ground F. The participation of the member in the business to which the interest relates is justified by the member's particular role or expertise. So in this case, both applicants are school governors who will have detailed knowledge of their schools, and Councillor Thomas has explained about his own background and about the background of Maggie Harris. I find this to be a very strong argument given the nature of the business, which is a proposal for the new all through 4 to 19 super school, as it's called in the Abergavenny Chronicle. I find this to be a very strong argument. What do members think about ground F? Peter? Yes, you're mute, Peter.
Is that better?
That's better. Thank you.
Thank you. I find it difficult to answer your question because I have no knowledge whatsoever of the expertise of all of the other members of the committees in question. It may be that there is a huge amount of expertise on those two committees without these members, but I don't know. So it would be making a decision,
okay,
completely without information from my point of view.
Matt?
Yeah, I understand the point that's being made there, but it's probably important that we remember that in terms of what prejudicial interest in the code of conduct are seeking to do here and what the dispensations are seeking to provide a degree of flexibility around is specific to the individual, and actually it's not necessarily a test that is either increased or decreased by the relevant knowledge of other members of committees. It should really be specific to the individuals. Again, if we take a step back and think about what the nature of the code of conduct is designed to do, it's designed to maintain confidence in the people who are involved in decision making and influencing decisions. So I understand the point, but I think the consideration of the committee needs to be specific to the dispensation criteria and the individuals.
Sorry, yes, I wasn't questioning the expertise of either of the two applicants. I need to make that clear.
Yeah. Okay. Any further comments on or questions on that ground F? We'll then move on to G, which is very specific grounds. The business to which the interest relates is to be considered by an overview and scrutiny committee of the relevant authority, and the member's interest is not a pecuniary interest. In some ways, this is very straightforward regarding Maggie Harris, because her participation at MCC will only be at the Children and Young Persons Select Committee, which is an overview and scrutiny committee, and she does not have a pecuniary interest. So I personally feel that ground G is very straightforward. Of course, it applies to both because Councillor Thomas is the chair of that committee as well. So in terms of participation of both applicants at the Children and Young Persons Select Committee, what is members' view of ground G? Does anyone object to that or have queries?
I can see no reasons to object.
Yeah. Irene, Peter, anything on that?
Agreed.
You agree with that? Yeah.
Yeah.
Agreed, yes.
Yeah. I'm wondering if our at this point, do our county councillor colleagues, Peter or David, wish to say anything, make any comment at this stage? No.
I think it's Chair. I think a lot of it's been said, and I don't disagree.
Okay, thank you. Thank you, David.
I'm all right, also, Chair.
Thank you, Peter. Ground I, it appears to the committee to be in the interest of the inhabitants of the area of the relevant authority that the restriction should be removed. And I think this relates back to the fact that this is it's a major project. It will have a lot of implications for the 3 schools and the children and the whole education system there, and effect on the town. And Councillor Thomas has multiple roles as well, as well the county councillor and a town councillor, and therefore, as it states in the application, is duty bound to represent the interests of the whole town. So it would be a serious thing for him to be restricted. Do members have any comments or questions on that argument? Do they find that a strong argument or not?
I am persuaded by that argument. I think that's a very strong and valid argument, and I also support it for Ms. Harris too on the information Councillor Thomas has provided.
Yes, Irene Cameron, I think it's a strong argument.
Okay, thank you. Thank you. And finally, we get to category J, which was introduced in 2016, which I call the catch-all category. It appears to the committee otherwise appropriate to grant a dispensation. And this is about, I suppose, us saying, does it actually make any sense that governors are discriminated in this way in the provision of the code based on who appointed them? So two county councillors, let's say hypothetically, one becomes a governor of a school via MCC appointment, one perhaps is a parent governor, which they were before they became a county councillor, one has an automatic exemption, one has an automatic prejudicial interest. And I think that's part of the discussion that Matt was raising as well. And it's an argument for me that if we feel that the code has unforeseen consequences because of this peculiar situation, then for me, the code carries less weight if the consequence of following it to the letter looks perhaps to the average observer to be rather strange and hard to justify. That's a personal opinion. And I think that's what this ground is about, actually. It's about the difference between those two subclauses 3 and 4 in paragraph 12.2.a and how they do or do not apply to you, whether if you've been appointed by MCC or whether you've been appointed a governor by a different route. But in both cases, you're members of MCC and your school governors. And that's about the way the code's written, and I suspect that's something that we, after this, we should write to the Welsh Government for clarification. However, in this case, how do members feel that as an argument for dispensation? Irene.
Yes, I think the general public at large would find it very hard to understand the ruling which would disbar them from taking part.
Yeah. Peter first and then Rian. Yeah.
I've read these paragraphs lots of times, and I'm struggling to find some reason why that was inserted.
Yeah,
and I can only think, and maybe Matt might have a view on this, and a proper view on this, that you know, to what extent does nomination by an authority limit or affect the way in which you represent views on the committee you're sitting? In other words, do you have a different constituency altogether because you've been nominated, and therefore you are duty bound in some ways to follow the line that your authority tell you to, as opposed to somebody who is not appointed by an authority and can presumably express personal views as freely as they want? That's just a theoretical musing. I don't understand the differentiation really at all.
Yeah. Just Matt, do you want to comment on that?
I'm sorry, Chair. I got disconnected halfway through that, but I think it's typical, isn't it? But I think that the point was, why are we in a situation whereby there's some sort of differentiation drawn between whether you're appointed by, in this case, the county council or the community council? Was that correct, Peter?
No, I was just wondering, Matt, whether or not the fact of being nominated by an authority meant that the way in which you represented your views on the committee would be changed. In other words, you would need to represent the views of your authority rather than having been personally appointed to a governing body in which you could express your personal views.
Yeah, I see. Yeah.
I see. Right. Well, so there's certainly nothing written down anywhere that would define how someone should act, and it's,
No.
it's possibly a question more for Councillor Thomas. But to draw on my experience, I would expect any elected member in any strata of government, quite frankly, to fearlessly and without favour represent their constituents and the wider county at large in any body with which they engage.
Okay.
Yes, thank you, Peter. That's a good question, actually. And I think, as I understand it, is what you're saying is almost is the role different to do with, is the role different if depending on your method of appointment?
Yes.
Is that what you mean?
That's what I mean. Yeah.
Yeah, perhaps Councillor Thomas, would you be able to comment on that? Is the role different for a governor if you're appointed by Monmouthshire as opposed to being, let's say, a parent governor, or are all governors expected to have the same skill set and build up the same knowledge and act collectively?
Well, you know, in answer to your question, as far as I know, and I've been on the governing body of Ysgol Gymraeg y Fenni back when it was first established, etc., and then latterly now again. But in my opinion, that has no bearing who actually appoints you. You were there as a governor to, in a sense, hold the head and the governing body to account, and to see that the children are properly educated and that everything is done in order, fairly and justly. And obviously, if anything arises in terms of grievance, etc., you could be on a grievance committee, whether you were nominated by the town or the county council or a parent governor. I see no differential in terms of duty and of great responsibility. So I personally, I don't see any difference, but I might be proved wrong.
I understand then. So, Peter, I think that means that yeah, the governor's role, you've got to be a good governor. It means the same thing, being a good governor, irrespective of the method of your appointment.
Yes, yes, yes. It would be interesting, however, were a particular authority to take a very, very strong position on a certain matter affecting the school, whether or not their nominated governor could speak the opposite.
Yes, and I don't know the answer to that. No, or whether they could be, in a sense, like a political group being whipped to vote or push for something in a certain way.
Yes.
Is that what you mean? Yeah.
Yes.
Essentially, have almost a political role with a small p. Yes. Yeah. Again, Councillor Thomas, does just for us, does that ever happen? Would Monmouthshire ever exert influence on the Monmouthshire nominated governors of a particular school?
Well, I've not been in that position, and obviously I'm a member of a political party, and I am in a whipped position. Yeah. But I think 100% most governors would, if they felt really strongly about something, and there's an issue in the Swansea Valley tonight about 3 schools being merged, etc., very controversial for those schools to close and move to another area, then you would expect the governor first and foremost to represent the interests of the children and the staff of the school that they are governor for. So, I suppose possibly it could arise, but I've not been in that position. Whipping normally is in terms of other decisions and within the political sphere in the chamber. So I've not had that experience.
Okay, thank you. Any more comments or questions on ground J? Rhian.
Just to confirm the original question, yes, I do believe it's the unintended consequences argument that you put forward, and it does feel a bit perverse.
Yeah.
And probably was an oversight in drafting. So yes, as a committee, we should probably raise it with the Welsh Government.
Yeah, thank you. And I'd just like to ask Matt a question now on, we've gone through all the grounds on process. Given where we are, would the best thing to do, first of all, be simply to vote on should we or should we not? Who is in favour or against granting dispensation in total? And then is it necessary then to go back and actually confirm the individual grounds? Because at first my first thought was that we would go through the grounds, the 5 grounds on each one, make a decision. But I think it may be better now to make an overall decision for everyone who is able to vote on in favour or against the dispensation. And then if we're in favour, then we need to go back and establish 1 or more grounds. Is that correct?
I think, Chair, you made a very valid point earlier that it only takes a member of the committee to agree with one of the criteria that have been raised here in order to vote for the dispensation. So I think an overarching vote is entirely appropriate.
Yeah.
I think actually the discussion and the minutes and the recording will stand on record as to how people viewed the individual criteria. So I don't think it's necessary to then go back and identify specifically. It might be different for different people. It might be that people might agree with all of the criteria and may wish to convey that very briefly, but you can open that discussion up. But procedurally, I don't think it's something it needs, as long as the vote on the dispensation is clear.
All right then, members. So we're going to go to the vote on the dispensation for both the applicants for a period of 12 months in their roles as Irene. Sorry.
I was going to ask about a time limit and if there was a time limit, but that's what you've just said. So
yes, it's 12 months. It's 12 months, and my understanding is that if this is a major project, that would be renewable again at our discretion.
Right.
So, members, I'd like to ask you then, could you indicate all of those who are in favour of granting the dispensation to both of the applicants in their roles at MCC for a period of 12 months? All those in favour? So I can see Irene, Peter, David and myself. Those against? Councillor Clark, Rhian, I didn't see you there.
Chair, I voted with you. I don't think you saw my hand.
No, sorry, I didn't. Matt, can you just confirm did you get a count there, please?
I did, Chair, yes. So I saw 5 members of the committee voting for dispensation and 1 voting against. Therefore, dispensation has carried.
Right. Thank you. And I think following your comments, we won't go through the individual grounds. There's no need to that. And that's the decision of the committee. So I don't think, is there any other items I need to raise at this stage? No. Thank you.
Chair, sorry, just to say, for the purpose of the minutes, I'm taking an action as well from the content of the discussion and the nature of your final vote to communicate into Welsh Government that this is potentially an unintended consequence of the drafting of the legislation.
Yeah.
And just to make that point and lay it rest there for any future redrafting.
Yes, great, thank you. So in closing, I'd like to thank Councillor Thomas for attending our meeting and to support the application, and also to thank all of you committee members and our officers, Nicola and Matt, for contributions and support. Just a reminder that our next scheduled meeting will be on our Standards Committee will be on Monday the 18th of October. You'll be pleased to know at our normal time of 10 AM. So I now close this meeting at 8:15 precisely, and thank you all very much.
Thank you.
Thank you.
And thank you for inviting